Morning, and thank you all for joining us today. I'd like to, before we begin, I'd like to recognize the people who are with me and some of you out there that have been the moving force behind, frankly, me getting to the place where I am today. First, I'd like to thank Senate Majority Leader Michael McCaffrey, law enforcement leaders, including Commissioner Parry, who's to my right. I know that Chief Brian Sullivan is here from the Rhode Island Police Chiefs Association, along with Sid Wardell. There are other police law enforcement members here, with Providence Chief David A, Cohen, along with Acting Colonel Kevin Barry. And to all of you who have worked on this issue for so long, welcome, welcome. We are here today to, I believe, accomplish two things. One is to focus or refocus our law enforcement efforts where I believe they truly belong, on drug dealers and not addicts. And at the same time, removing a significant barrier to those who are in recovery, a felony arrest or conviction. Under existing law in Rhode Island, simple possession for personal use of less than an ounce of a drug remains a felony, punishable by up to 3 years in prison. The legislation that we would propose today would reclassify simple possession of less than an ounce of any drug for personal use as a misdemeanor, and the maximum prison term would be reflected to reflect misdemeanor conduct. I've been a state or federal prosecutor for over 20 years. As an assistant attorney general and as an assistant United States attorney, I prosecuted more felony drug cases than I can count. Some of those cases were simple possession cases, like what we are addressing today. And some were serious drug trafficking cases. In fact, when I was U.S. Attorney, we prosecuted, with the help of Providence, the state police, and DEA, the largest heroin and the largest cocaine trafficking cases ever brought in this state. I like to think that those of us in law enforcement know the difference between a serious narcotics case and one that is not. As United States Attorney, I also spoke with substance abuse counselors, doctors, other health professionals, and most significantly, people who are addicted and the parents and friends of people who are addicted, and those who are in recovery as well. I moderated panels on addiction and recovery at open meetings in cities and towns across the state. How many times did I hear a parent talk about their concern for their adult children suffering from addiction? Did they view those children as felons? I did not. During my last year as U.S. Attorney, I made over 20 visits to high schools around the state. Of all those visits, the most powerful voice that I heard, the most courage I've ever seen around this issue, was a high school senior who talked about her path to addiction and to recovery. Did I view her as a felon? I did not. Did she view herself as a felon? I hope not. I say all of this because I look at drug addiction and the public health crisis we face today through the lens of that experience. That experience has taught me that there is a substantial difference between those who traffic in drugs and those who simply possess them, fueled by addiction. Drug traffickers deserve our most significant prosecutorial efforts. They are the ones fueling addiction, and they are the ones preying on addiction. And I have no tolerance for them. Identifying them and bringing them to justice is one of our top priorities, along with gun violence. If you are a drug dealer, this legislation doesn't protect you. Just the opposite. It pivots our enforcement efforts directly on you. If you deal drugs in any amount, the law remains the same. You are a drug dealer and a felon, and we will prosecute you. If you possess over an ounce of drugs, the law remains the same. You are a drug dealer and a felon, and our office will prosecute you as one. If you possess under an ounce of drugs, and yet your intent is to distribute them to others, the law remains the same. You are a drug dealer and a felon, and my office will prosecute you as one. But those who simply possess drugs and who are addicted and cannot escape, at least not yet, the cycle of addiction, well, those people are different and should be treated as such under the law and by law enforcement. People who simply possess small amounts to use themselves, in my view, that is not felonious conduct. It should not be prosecuted and punished as such. I know that in some quarters this proposal may raise concerns, and I am aware of those concerns, and I respect them. Many of the people who have those concerns have been friends and colleagues for a long time. I know that the increasing prevalence of Chinese-sourced synthetic fentanyl distributed by the Mexican cartels has made this public health crisis so much worse and so much more dangerous than it would be otherwise. And yet I believe that if an individual has fentanyl in his or her possession, that person either doesn't know it or is in need of serious help if it's for personal use. Again, our focus, our laser-like focus, needs to be on, and will continue to be on, dealers, not users. And our criminal justice system should reflect that distinction. Why is that distinction so important? Well, if I learned one thing as United States Attorney, I learned how difficult it is for someone getting out of prison or someone with a felony conviction to get back into the workforce, to get housing, to get back on their feet to support their families. Just on Friday, I was at Open Doors, and I heard the story of a young man who, after he got out of prison, the only job he could get was at TGI Fridays, and he couldn't make enough to secure housing. But because he had worked behind the walls in a warehouse, he was able to get a job with a warehouse company. And today, every day, he goes into work at 9 o'clock, comes home at 7 o'clock in the morning, and drives to Boston as a delivery man. But to hear his story on Friday reminded me how hard it is to get back on the road if you have a felony conviction. And by removing these felony convictions from those who are addicted, I believe we take away a barrier to their recovery. To some, this may seem very forward-looking, but the trail has been blazed by others. More than 20 states and most of our neighbors in the Northeast, as you can see from this map, already view simple possession as non-felony conduct. The world has changed so much since I became a prosecutor in 1996. Back then, I was assigned to Courtroom 9 in Providence, where the probation violators go to be prosecuted, or come to be prosecuted. And while I was there, I prosecuted individuals, violators, who sometimes went to prison based on a previous charge of possessing a needle and syringe. At the time, that was a 5-year felony. Eliminating that law in the late 1990s, and I know Dr. Rich is here somewhere, and Doctor, thank you for your work on that particular law. Eliminating that law at the time, here and elsewhere, drew plenty of objection and took plenty of time. And yet, would any of us seriously argue that that law should remain on the books today? The world has changed. We've got to be smarter in a whole host of ways as we rethink our criminal justice system. Justice demands it. Our limited resources demand it. I want the office's prosecutors focused on the cases that matter the most, whether they be civil or criminal cases. Cases that have the greatest impact on the people of this state. I believe that this legislation is fair, and I believe that it is just, and that is why I believe in it. Thank you. So now,